everyone, welcome back to my channel. I'm 𝐟𝐨𝐫𝐿, a Broadway performer, writer, and theater journalist. If you're new here, welcome. Don't forget to click the subscribe button for more content from your theatrical Hermione Granger. So let's get started. They don't give you an instruction guide when you decide you're going to be a creator. Maybe they should. In the same way someone should teach us how to do our taxes before we turn 18, there are ins and outs of the creative process that we usually have to glean on our own, often with problematic consequences, whether through ignorance or deliberate mishandling. One of those things that made headlines last year on multiple fronts is issues surrounding intellectual property, or what exactly your rights are as a creator to both defend your own work or adapt someone else's. I know, sounds super exciting. I actually find it to be kind of fun. In August of last year, Netflix sued the Grammy-winning creators of Bridgerton the musical for copyright infringement. A few weeks later, a Texas church, the McAllen and 𝐟𝐸𝐫 Productions, had their production of Hamilton shut down after altering lyrics and adding text to the show to promote an evangelizing and at one point anti-LGBTQ+ message, not to mention that they simply failed to properly obtain the rights in the first place. There are numerous musical parodies of well-known properties, some successful and legal, and some that have been forced to shut down for copyright infringement. I myself am the creator of Forever Deadward, a musical parody of the Twilight Saga, as well as other YA and vampire entities that played at New World stages, and I know more about parody, satire, legalities than any non-lawyer should. And keeping that in mind, I am not an attorney. I have consulted with many, but I am not an attorney, so make sure to do your due diligence. So, what exactly is happening here? Copyright refers to the legal rights given to the originator of creative material. In general, in the US, a copyright lasts 70 years after the literal death of an author, at which time the work enters the public domain, meaning anyone can do anything with the work without getting permission. Please note there are exceptions to this, and you should always do your research before deciding to adapt a work or assuming something is in the public domain. An obvious example are the plays of Shakespeare, all of which are in the public domain. Imagine if every production of Romeo and Juliet had to get permission from Shakespeare's estate. But during a creator's life, and for several decades after, copyright helps protect the value of their work, giving the creator the ability to safeguard it from being copied to the degree where they cannot sell or profit from their work effectively. Copyright encourages creativity, guaranteeing a creator the ability to earn a livelihood from their work. In essence, the question to be asked is, does another creative venture substitute or destroy the original market for a particular work? So basically, if person A writes an award-winning best-selling novel, person B can't reproduce the novel and sell it themselves under their name. That's blatant copyright infringement, as it prevents person A from earning a living from their work. That being said, there are legal ways of using or referencing a work that has not entered the public domain. Parody. Parody seems straightforward. In its simplest terms, a parody, according to the New Oxford American Dictionary, is an imitation of the style of a particular writer, artist, or genre with deliberate exaggeration for comic effect. Sounds almost interchangeable with satire, doesn't it? But legally, it's not. And this is where some projects have gotten into hot water, and how some big organizations have made arguments against works they simply want out of the way. In layman's terms, a parody is something that makes fun of the specific source material they're referencing, whereas satire uses source material to make fun of a broader subject.
How good of you to come and see me. And how pretty you look.
Oh, Ren, how you do run on teasing a country girl like me?
Thank heavens you're not in rags. I'm tired of seeing women in rags. Turn around. Oh, you look good enough to eat. And prosperous, too.
Thank you, I've been doing very well.
What brings you to Tara? You vixen, you. Starlet, I love you. That gown is gorgeous. Thank you. I saw it in the window and I just couldn't resist it.
A landmark case in point is the 1997 lawsuit against the book, The Cat Not in the Hat, which used the framework of The Cat in the Hat to parody the O.J. Simpson trial. The representatives of the book claimed it was a parody. The plaintiffs said it was not. Ultimately, the court ruled against the book due to the fact that it was deemed satire, not parody. The book used the Cat in the Hat format, text, and structure not to parody The Cat in the Hat, but as social commentary about the Simpson trial. The argument being that they didn't need the Cat in the Hat material to make their point, so it wasn't necessary for them to reference it. And satire is not protected the way that parody is. Parody is part of fair use. Satire is not. Inspired by, but completely transformative. For example, 50 Shades of Grey started its life as fan fiction of the Twilight Saga, imagining what would happen if Bella and Edward met in college instead of high school, and Edward's dangerous nature extended to his preferences in the bedroom. When the fan fiction became successful, there was talk of publishing it as a novel. In order to do that, the author needed to transform any elements that connected it with Twilight. Bella and Edward became Anastasia and Christian, and there was nothing supernatural anywhere in sight. In essence, anyone who didn't know its history would have no idea it was connected to Twilight, thereby not offering any competition with Twilight readership. That's the key here. The original author must have no grounds whatsoever to say that you are potentially taking sales away from them. This includes anything from an adaptation that's too close to comfort to a sequel. Theoretically, the original author could write a sequel themselves, meaning yours would compete. It's not well known that Jonathan Larson's musical Superbia, immortalized as the show Jonathan is workshopping in Tick, Tick, Boom, was originally born out of Larson's desire to write a musical adaptation of 1984. When he couldn't secure the rights, he decided to write a dystopian musical with a completely original plot, allowing him to move forward. Work based on biography or history. This can get into some tricky territory. Technically, any historical facts that are common knowledge are in the public domain. However, tread with caution if the person or people you want to write about are still alive. Technically, there are ways around getting permission. Look at the number of unauthorized biographies out there. But it is very easy to get sued for defamation, even if you don't consider your work to be defamatory. Or for royalties, since people do have rights to their life stories. In 2011, Warner Brothers settled a lawsuit regarding its Broadway musical, Baby, It's You. The musical told the story of Florence Greenberg, the woman who discovered the Shirelles and created Scepter Records. However, according to rumors, the Shirelles didn't find out their story or likenesses were being featured in a Broadway musical until they happened upon the New York Times review. Members of the group, including Dionne Warwick, sued Warner Brothers' theatrical division, their representatives stating that, having been cheated out of their royalties when they were young and popular, they are now victimized again. If you are not writing about a subject involving anyone who is alive, you still need to tread with caution. General facts that appear via multiple public sources are fair game, but if you want to adapt a specific biography or nonfiction work, you must get permission from that author. That is likely one of the reasons that the musical Hamilton has such a strong relationship with Ron Chernow, the author of the biography Alexander Hamilton, which creator Lin-Manuel Miranda has stated was his inspiration for writing the musical. It is likely that Miranda had to get the rights from Chernow to specifically adapt his biography. Educational, critical, editorial purposes. Like this. This basically is what allows schools to show films in class or journalists to reference parts of copywritten material in reviews or articles. This is part of fair use. And note, good faith criticism does not count as destroying the market. However, also tread with caution here, as a critical editorial work must include commentary and transformation. Like this. A review clearly falls into this category, but for example, there was a notorious case where J.K. Rowling, actually well known for her openness and anti-litigious reputation with parodies, creative works, etc., related to the Harry Potter series, sued the authors of a Harry Potter encyclopedia. The defendants claimed that their work was transformative and educational, but by the nature of it being an encyclopedia, they had to quote large passages of the original text unchanged. Rowling countered by stating that way more of the encyclopedia was direct quotes from her books than was actually needed in order for the authors to accomplish their goal, and lacked needed commentary, etc., on top of the fact that Rowling planned to write her own Harry Potter encyclopedia, and this encyclopedia would destroy the market for hers. Ultimately, the court sided with Rowling. Charity performance. You still need to go through the rights holders, but generally, if it's for charity and you're not making any money or inappropriately transforming the original work, it's a lot easier to make this option happen. Authorized adaptation. As this heading suggests, this is an adaptation where the rights have been granted to the adapter. But be aware, this means the original creator can be as involved or not as they want to be. They might be entirely hands-off and let you do your thing, or they may have numerous specific demands, such as P.L. Travers during the making of Disney's adaptation of Mary Poppins. Creators can pull the rights at just about any time, so you will need to work with them as the piece progresses. And getting the rights to a property usually involves paying the original creator and guaranteeing them royalties. And please note that fair use is not limited to parody editorial educational purposes, but these are the most commonly known and commonly used aspects of fair use. So, that all seems well and good. So what exactly happened with the Bridgerton musical? At the start of the pandemic, writing duo Abigail Barlow and Emily Baer filmed TikToks that quickly went viral based around the idea, what if Bridgerton was a musical? Bridgerton, for anyone who doesn't know, is a successful Netflix show based on the novels by Julia Quinn. Their TikToks turned into an unofficial Bridgerton musical album that went on to win a Grammy Award for Best Musical Theater Album, beating Andrew Lloyd Webber's Cinderella and Conor McPherson's Girl from the North Country. The success of that album led Barlow and Baer to take the project further, presenting concert versions of the show with Broadway performers at prestigious venues for profit. After a for-profit, the for-profit is important, performance of the musical at the Kennedy Center in D.C., crossing paths with Netflix's live venture, The Bridgerton Experience, which was set to be presented in the DC area at the same time, Netflix sued Barlow and Baer for copyright infringement. Fans of the musical went into an uproar, feeling this was a David and Goliath situation where the creators were being bullied and Netflix should do the right thing and partner with the musical. There are certainly many cases of big corporations bullying small creators into taking down work which they legally don't have to. This is one of the most popular ways to force legal parodies to shut down. But in this case, the situation isn't so black and white. According to Deadline, who first reported on this case, Netflix originally hailed the concept when it debuted as a free online homage, but when that expanded into a profitable business, things became sticky. In an official statement, Netflix added, "Netflix supports fan-generated content, but Barlow and Baer have taken this many steps further, seeking to create multiple revenue streams for themselves without formal permission to utilize the Bridgerton IP, intellectual property. We've tried hard to work with Barlow and Baer, and they have refused to cooperate. The creators, cast, writers, and crew of the Netflix show have poured their hearts and souls into Bridgerton, and we're taking action to protect their rights." Showrunner Shonda Rhimes and original author Julia Quinn have released similar statements in support of the lawsuit. Barlow and Baer said that they received Netflix's permission to proceed with the project. It is possible to read the entire Netflix filing in regards to this case. For easy access, NPR has posted it publicly. I'll put a link below as well as links to other articles that I reference. And doing so turns up some interesting points. On July 26, 2022, over Netflix's repeated objections, Barlow and Baer staged a massive for-profit stage show to a sold-out audience at the Kennedy Center. The live show featured over a dozen songs that copied verbatim dialogue, character traits, and expressions. Barlow and Baer misrepresented to the audience that they were using Netflix's Bridgerton trademark with permission, while Netflix vigorously objected. Barlow and Baer also announced they intend to stage yet another performance of their unauthorized derivative works at the Royal Albert Hall in London, making this a world tour. They even promoted their own line of Bridgerton-themed merchandise. After Bridgerton was first released, Barlow and Bear, along with countless other fans, started posting about the series to TikTok, including creating musical compositions based on characters, scenes, dialogue, and plot points from the series. When asked directly, Netflix told Barlow and Bear time and time again that such works were not authorized. Barlow and Bear chose to move forward with that knowledge and release an album recording. At each step of the way, Barlow and Bear's representatives repeatedly assured Netflix that they understood Netflix's position and led Netflix to believe that Netflix would be consulted before Barlow and Bear took steps beyond streaming their album online in audio-only format. Barlow and Bear's agent said that they had no interest in interfering with Netflix's rights or in being known only as the Bridgerton girls. Many specific examples are given as to how the Bridgerton musical infringes on copyright, both in concept, dialogue appropriated, and other factors. Netflix adds that Barlow and Bear repeatedly admitted that they intentionally based every single song on the creative elements of the series. Netflix references their future endeavors related to Bridgerton, such as the Bridgerton experience, merchandise, etc., which is in conflict with the musical. They say Barlow and Bear have admitted publicly that they don't own the IP. Yet, Barlow and Bear's attorneys have taken the position that they somehow do not need a license because Netflix did not file this lawsuit sooner. That is not how copyright law works. This clarifies some things. Many fans of this musical were angry at Netflix for not trying to work with Barlow and Bear, and if they had no intention of doing so, why didn't they file this suit earlier? Paraphrased. According to this filing, Netflix did try to work with Barlow and Bear Bear violated the terms set forth. They didn't file this suit sooner because they were supportive of the venture until it became a for-profit project that was in direct competition with Netflix's ventures. This show also cannot be dubbed a parody. According to everyone involved, this is a serious adaptation of the source material and is not trying to make fun of any elements of Bridgerton. 𝐬𝐻𝐫𝐞 of 𝐬𝐻𝐫𝐞 Theater does a wonderful deep dive into this lawsuit, and if you would like more information, I recommend checking it out. Again, link below. This project also cannot rightly be dubbed fan fiction, as again, it is a straight adaptation of the source material, not a made-up story in the world of Bridgerton. And even if it was, fan fiction is a realm of copyright law that, in essence, is still very much the Wild West. Laws are not entirely clear on the subject, as is evidenced by the ongoing Omegaverse suits, which have gone all the way to federal court. When fan fiction was completely the domain of free online postings, it was a bit no harm, no foul, as no money was being made by anyone, and therefore no one was infringing on royalties, and was such a niche thing that it was unlikely anyone was choosing to read fan fiction instead of purchasing the original book, film, etc., on which the fan fiction was inspired. But now that fan fiction can be turned into a huge moneymaker, dependent upon the need to be transformative, mentioned earlier, and can exist in worlds entirely made up online where no one owns a copyright, who created what first is muddy territory. New laws are being written every day, so in this arena, it's better to be overly cautious. If you would like a deep dive into this area of copyright, I highly recommend Lindsay Ellis's video essay, Into the Omegaverse, How a Fanfic Trope Landed in Federal Court, and her follow-up, Addison Kane's lawyer emailed me, and it only got worse from there. Another very different example of IP infringement is the McAllen production of Hamilton, and it later emerged their production of Disney's Beauty and the Beast. The church claimed they had permission to do Hamilton, but representatives of Hamilton claim otherwise, and especially of note is that the church was never given permission to alter any of the text. Also, even though there's exceptions for religious institutions, the rights have not yet been released for regional productions of Hamilton. So that's a whole other thing. Or they certainly had not been released as of the McAllen's production or the making of this video. There are certain copyright exemptions for religious institutions. For example, churches are allowed to use songs as part of their worship service without paying royalties. That right does not extend, however, to doing large portions of a show or changing material. In fact, it is never legal to perform large sections of or the entirety of a work without permission, even if you're a religious institution and even if you are not selling tickets or making any money. Truth be told, there are a lot of times that companies will look the other way. I've seen many an elementary school production of, say, The Lion King, where Disney wasn't knocking down their door. But that doesn't mean it's legal, and it doesn't mean you can't be shut down. Likewise, whatever the circumstance, it is 100% illegal to change the text of a work you are performing unless you have received specific permission, even if you have been given the licensing rights. There are numerous examples of productions that have obtained the rights to a show and then taken an axe to the script only to be shocked when they get shut down. Honestly, this is a positive thing. It protects the author's work and intention, and theoretically, it inspires others to create original work. Just as Jonathan Larson created his own fantastic dystopian tale when he couldn't get the rights to 1984, so you can use your creativity to create an original story that examines the themes and ideas you want to explore. The McAllen could have written an original musical exploring evangelism without trying to shoehorn that idea into previously existing works. However, an original show wouldn't have come with the brand recognition and love that Hamilton and Beauty and the Beast garner. And this is a big aspect of their copyright infringement. The McAllen stealing that brand recognition and using it for their own benefit is detrimental to the original creators. So what does this mean for you? If you are a creator, it's important for you to protect your work. Nowadays, it's pretty easy to prove basic ownership. Everything from sending a work as an email attachment to document when it was completed, to even basic writing programs coming with a time and date stamp are helpful in this regard. But in the US, if you want to officially copyright your work, you can visit copyright.gov. You can also register a script with the Writers Guild of America, which comes with less protections than a copyright registration, but is a faster and cheaper way to at least establish ownership. Keep in mind, you cannot copyright a general idea, only a specific text. No one can own a trope or a concept. If you are thinking of adapting a pre-existing work, do your due diligence. Check if something is in the public domain, and I mean really check. For example, Peter Pan is technically in the public domain, but only the book. Before the book, there was the stage play, and author J.M. Barrie left those rights in perpetuity to the Children's Aid Society. So technically, you are free to adapt the book, but you can't adapt the play. I know, tricky distinction. Likewise, the Wizard of Oz books are in the public domain, but not the MGM film rights. That means that if you reference things that are specific to the film, such as the ruby slippers, or even saying yellow brick road instead of the road of yellow brick, you can find yourself in hot water. Even the title, The Wizard of Oz, may not be safe, as the title of the original book was The Wonderful Wizard of Oz. That's one of the reasons that the creators of the musical Wicked came up with some of their fun turns of phrases. Notice that Nessa Rose says jeweled shoes when receiving the jeweled slippers from her father, not ruby slippers, although they do a fun lighting moment where the slippers glow red at one point, but they are never called ruby slippers. And how Glinda says, that's right, you just take that one road the whole time, not follow the yellow brick road. If you want to do a straight adaptation of a work not in the public domain, get the rights. IMDb has access to the contact info for the representatives for almost every writer, creator, etc. in the industry. It doesn't hurt to reach out and ask. That's how a lot of people have gotten rights. If they say no, use your initial idea as a jumping off point to create something totally original and unique. And if you do want to venture into a fair use adaptation, a parody, etc., make sure you've got all your bases covered and do your research to make sure what you've written is really protected under fair use. Run it by others. I highly recommend Volunteer Lawyers for the Arts. And if you are a member of the Dramatists Guild or Authors Guild, they have fantastic free legal assistance as well. Zachary Allender and Julie Ahrens are leaders in the field of IP law and two of the lawyers most highly trusted and recommended to consult, especially in this area. And I personally can't recommend them highly enough. If need be in communication with the rights holders, and above all, make sure your work is in no way competitive with the original work in question. I hope this helps. Have fun creating.